And if a motion is not filed or an objection is not made on a particular issue, then that issue may not be preserved for appeal. Hello again. This is Lana Manitta with Rossen Law Firm, talking to you again today about federal criminal motions practice. Remember to like and comment on this video and subscribe to our channel. We try to present educational videos on a wide variety of topics related to criminal defense in both federal courts and the state courts of South Florida. So, what are we talking about today? We're talking some more about criminal motions. Now, within reason, within the boundaries of having a good legal and factual basis for a motion, you can't file a frivolous pleading, for instance. There really aren't other limitations on motions that can be filed in a federal criminal case. There might be literal page limits and word limits, but not to the number or the subject matter as long as it's not a frivolous motion. And if a motion is not filed or an objection is not made on a particular issue, then that issue may not be preserved for appeal. And so it's really important, if you have an issue, to get it on the record, file that motion, make that objection at the appropriate time. Now, we've discussed before in prior videos that a lot of the motions a criminal defense attorney in federal court is going to file arise from discovery review. Getting your eyes on the evidence, seeing more about the government's case is where the ideas for suppression, exclusion, or limiting the evidence might become clearer. But there are challenges that can be made before that to the indictment itself. That's what I'm talking about today in the second video in a series of videos talking about motions challenging the indictment using the top-down, literally top-down approach to the indictment when determining what, if any, challenges can be made. In a prior video, we covered subject matter, jurisdiction, and venue, which touch upon the information found in the very top line of an indictment, where it tells you that it's a U.S. district court in a particular district. Now, we're moving down the page to what is called the style of the case, and that's where the parties, the case number, and sometimes the counts of the offenses that are being charged are listed. So the parties are United States versus the defendant or the defendants, for instance. So one of the questions that counsel has to ask themselves relates to the presence of your client's name in the indictment. And the first, simplest question is related to personal jurisdiction. Does the court have personal jurisdiction over my client? Meaning, can or should my client be brought to answer charges before this court? Now, personal jurisdiction is established when the defendant is brought before the court by proper criminal process. And what do I mean by that? Proper criminal process can be a summons or a warrant, an arrest warrant. Now, while you are unlikely to find a fatal flaw, meaning some flaw in this process that's going to get the case thrown out, especially one that can't quickly be remedied by the government before your client, leaves the district, you should still, nevertheless, be on the lookout for any significant errors in the criminal process that's brought your client before the court. Now, since we're talking about cases that have been indicted already, that means that a grand jury has charged the defendant and issued an indictment. That means there's not going to be what's called a preliminary hearing at which you, as the defense attorney, can explore and challenge probable cause to charge your client. That's already been covered. But that doesn't mean you can't begin an early challenge to the evidence or the strength of the evidence, because one of the considerations the court has to undertake at a detention hearing is the weight of the evidence against the defendant for whom detention is being sought by the government. So if you have a case where your client's been indicted and the government is seeking detention, meaning they're going to be held in jail while the case is pending, you can have a detention hearing and get good testimony on the record about the scope of the allegations against your client, the different types of evidence the government may have supporting those allegations. And that early testimony can be invaluable because at this stage of the case, which is very early on in the first couple of days, you haven't received any discovery from the government. So this is the first potential challenge to the indictment, even though it's really couched in terms of detention. That's the first real challenge that's available to you if you're not going to have a preliminary hearing. So we will be talking about more issues that might be hiding in the style of the case, meaning that area of the indictment that has the names of the parties, the case number, and the counts that are charged in a future video. But for now, make sure you like and comment on this video, subscribe to our channel, and thank you for watching.